Okay. Thank you all for joining this press conference, I guess. It's a little bit weird to be sitting here talking to my computer, but I know that all of you are out there. Today, we wanted to talk about no-knock warrants, and I'm joined by a bipartisan group of prosecuting attorneys that represent the three largest counties, the counties that are home to Cleveland, Columbus, and Cincinnati today, to talk about this issue. It's important, I think, to start off with understanding what this is precisely. The idea behind a no-knock warrant is, first of all, not really governed by the Constitution. It's a statutory matter, and it's different from state to state. So Ohio doesn't necessarily look like any of the states surrounding us, although there's certain, I suppose, commonalities in the way we think about these things based on what they're really about. And that's the idea that sometimes a search warrant is going to be conducted on a premises where somebody inside is armed and very dangerous. Think a narcotics operation that's slinging, major weight of fentanyl or heroin. Or think a human trafficking operation where they're selling women or children for sex. These folks are looking at huge potential penalties, could spend decades in prison or longer even, and they don't want to comply. They're armed, usually used to using force, and pose a significant threat to law enforcement who are attempting to bring them to justice and executing that search warrant. So the search warrant law generally in Ohio requires that the police that have a warrant have to first knock and announce that they're there with a search warrant, and then they have to give an opportunity for the people inside that premises to respond before they're allowed to use force to enter the premises. They are allowed to use force to enter the premises at that point. The no-knock is designed for those rare occasions when there's a serious problem, a serious issue of officer safety, where if you knock on the door and say police, they might answer the door with a burst of automatic weapons fire. So it's supposed to be an extraordinary solution. The judge is allowed to waive the announce and knock requirement, which is found, by the way, in 2933.231B of the Ohio Revised Code. So we are looking to have some changes made to that statute and Ohio law. Now, why are we doing this? First of all, no-knock warrants are certainly not common, but they're being used more frequently than they have in the past. And secondly, Ohio is now a castle doctrine state, which means that people are allowed to use deadly force to defend themselves in their own home. And that can mean, in a situation where the police have not done the knock and announce, that we might see the bad guy shooting back without realizing, or shooting at the intruders without realizing that they were police. That is an inherent conflict in the law. When the original statute in 2933 was written, the Castle Doctrine was not the law in Ohio. Further, we've got local communities that are, for very good reasons, debating the use of no-knock warrants, and in some cases are considering an outright ban. All four of us on this call have been prosecutors, have worked with law enforcement, and I understand that there's limited circumstances where a no-knock warrant is indispensable to preserving life and to doing these very dangerous things as uh, safely as possible. So our goal is to tighten the requirements and the controls on the use of this tool, um, but not to eliminate it entirely. So we are sharing with you today a letter that we have written to the General Assembly, leaders in the House and the Senate, as well as the governor of the state of Ohio, asking for the following changes. First of all, the statute right now simply says that there has to be a showing in the affidavit that there's a risk of serious physical harm to officers. That's not really high enough standard. For example, there are times when just the affiant saying, well, we know that they have a gun, that there's a gun in the house, is enough that a judge will authorize a no-knock, a waiver of the knock and announce provisions. There are counties in Ohio where there's a gun in the house applies to a majority of the houses, and that doesn't seem to be enough of a showing to warrant the extraordinary remedy of eliminating the knock and announce requirement that's in statute. So we're asking for that to be changed to a substantial risk of serious physical harm to officers. Obviously, that calls for the judge to make a determination based on all of the facts available, but it's certainly more than is frequently used today. Secondly, the statute uses a undefined term called good cause. Well, we have a well-developed body of language, of case law about language on these sorts of things. And we would like to see that good cause clarified to either read or be defined as equal to probable cause, which is the same standard that the Constitution requires for the warrant itself. It should be the same standard applied, in our view, to the application for a waiver of the knock and announce requirement. And that's as distinguished from the reasonable suspicion standard that's also in case law that might be mistakenly confused as being equivalent of good cause. We would like to make an absolute prohibition so that misdemeanor drug possession and misdemeanor possession of drug paraphernalia cases without something more would be insufficient to warrant or to get a no-knock warrant at all, ever. We're asking for a requirement that the officers executing the warrant wear readily identifiable markings and as soon as possible upon entry identify themselves as police. And finally, absent some exigent circumstance, we believe that officers who have body cams ought to be required to wear them, or if the agency has them, the officers making the entry are required to wear them and to activate them upon entry. So that is an outline of the reforms that we're seeking. These are more nuanced and more surgical than an outright ban, and maybe a little bit harder to understand, but it does a better job of balancing the need for law enforcement in the case of serious crimes to be able to execute search warrants safely against known dangerous suspects, and the right of the community to reside peaceably in their homes. So with that, I would like to turn this over to my colleague from Cuyahoga County, whose county seat is Cleveland, Michael O'Malley. Michael?
Dave. I just want to reiterate and reiterate what Attorney General Yost has indicated, as well as thanking him for his leadership, as well as my colleagues in both Franklin County and Hamilton County for supporting this issue. In Cuyahoga County, we issue hundreds of search warrants per year to law enforcement, hundreds. And as the Attorney General has indicated, we rarely issue no-knock warrants. We average less than one no-knock warrant per year. But when law enforcement needs that tool, it is critical that it be available to them for their safety of all law enforcement personnel at the scene who are executing those warrants. That's why clarifying this issue, making the standard clear, raising it, as well as maintaining this tool in their belt is good for law enforcement in my county. And again, it is a tool that is rarely used, but when necessary, it needs to be there for them. Thank you. I will now go to my colleague in Franklin County, Ron O'Brien.
Thank you, Michael. I appreciate it. And I also would like to commend our Attorney General, Dave Yost, for contacting me and the other Metro prosecutors to talk about this issue and help draft the letter to send to the governor and the president of the Senate, as well as the Speaker of the House, seeking these changes. Columbus probably uses a no-knock search warrant more often than they do in Cleveland, typically on drug cases, and typically on when SWAT has an arrest warrant for someone who is a high risk felon, either wanted for murder or a series of armed robberies or rapes. They will sometimes ask for that kind of entry. Again, it's a small percentage of cases, but I have found over the years, when used on a drug case in particular, that it causes the people in the house to think perhaps it's a robbery in progress because they have drugs and money. And so it's high risk for the occupants, it's high risk for the officers involved. So the circumstances justifying a no-knock search warrant, I think it makes sense to narrow, as this proposal does, as well as make sure we have a uniform standard. Here in Franklin County, we have 32 law enforcement agencies that will apply for and execute search warrants, and it would be best served by having a common standard. The City of Columbus City Council this summer, after the incident in Louisville involving Breonna Taylor, adopted a ordinance that restricts the circumstances when their own police officers may apply for and get a no-knock search warrant. And they did discuss the potential ban of it. They did not come down on the side of banning it, but they did limit the circumstances and provide an internal approval process by a deputy chief of police. And I think the effort that Attorney General Yost has taken, providing the additional substantial risk of harm to officers, as well as prohibiting its application to misdemeanors, and then providing that there be probable cause rather than a undefined term of good cause, all makes sense. And I look forward to working with the General Assembly to see this adopted. And with that, I would like to introduce my colleague in the city of Cincinnati, which is Hamilton County, Ohio, my good friend Joe Dieters.
Hey, Ron, thank you. And thanks for all of you for being on this call. I especially want to thank the Attorney General for his leadership in this effort. A no-knock warrant is, in fact, as previously mentioned, a valuable tool for some offenders for law enforcement to deal with. And keeping that in mind, I think what Dave Yost and through his leadership is doing is he's providing a tool of transparency. I hate that word, but I'm going to say it. He's providing a level of transparency to when these things are used. Now, I just heard Ron say his local city council was passing some type of prohibition against this. The city of Cincinnati looked at this and determined that their charter prohibits city council from dictating to the police how they execute these no-knock warrants. And the city manager can order it, probably through the mayor, but the city manager can in fact order it. What I do want to say though, which is I think very important, if I get a sense of what's going on in Ohio, the police in this state and certainly in Hamilton County are not busting down doors, acting like a bunch of cowboys with these no-knock warrants. As a matter of fact, we pulled our data from the last 5 years. CPD has asked almost every year for less than 10 no-knock warrants and have served less than 5. So you're talking about thousands of search warrants that are carried out by CPD, and the reality of the fact is that our no-knock warrants just are a minuscule amount of the search warrants that are executed, at least in Hamilton County. The sheriff's office tells us in the last 10 years, the Hamilton County Sheriff's Office, if they've executed 10 or 20 no-knock warrants in the last 10 years, it would be a lot. They just don't do it. And CPD in particular, I know Ron was just mentioning this, they've got internal controls in terms of many levels of review before even going to a judge asking for a no-knock warrant. So it's rare. I want to emphasize that. It just in terms of the big picture, we don't have cowboys knocking down doors, throwing people on the floor and things like that. It's just not happening. However, the Attorney General Yost and his leadership to show exactly what it is that has to be approved by a judge elected separately by the electorate, that they have demonstrated some form of probable cause that this is a dangerous situation. In those limited times, they can obtain a no-knock search warrant. And again, David, thank you for your leadership on this. We're happy to cooperate with Cuyahoga and Franklin County, and whatever you need from us, just let us know. And I'll turn this back over to Dave for any questions from the media.
Thanks, Joe. And Ron and Michael, thank you for you're great leaders in your communities. And each of you has been a leader over a long period of years and thinking about legal issues and law enforcement here in Ohio. So I have great respect for you and appreciate you being part of this initiative. With that, I'm happy to, and my colleagues are happy to try to answer any questions or respond to any concerns you might wish to raise.
Jeremy Pelzer with Cleveland.com is up first.
Hi, Attorney General. I know I'm up first, but I wanted to instead ask you about the subpoena you'd received from the feds regarding the HB6 investigation. Just wanted to see what information you provided to them, and specifically how much, what information you provided regarding any contact your office had with people about your decision to let that referendum go ahead, that potential referendum. Thank you.
So for every referendum in Ohio, the Attorney General has a job to review it for truthful and fair language on the initiative. It's a very ministerial process, and it happens in every initiative or referendum campaign. It happened here, and the subpoena asked for the organic documents, very routine kind of thing. Let me suggest to you that it's similar to a bank providing bank records when there's been a theft or an embezzlement from a company or an individual. So the U.S. Attorney has said that the Attorney General's office is not a target in any way. We simply provided some original documents that are part of the timeline.
The next question is from Helena with WLWT.
Hi there. I actually have two questions. So here in the city of Cincinnati, a city council member recently drafted a motion calling on the city manager to ban no-knock warrants. The city solicitor came back with an opinion kind of referencing a few exceptions, which you guys talked about, exceptions to the rule when it comes to no-knock warrants. Exigent circumstances and working with task forces were the two mentioned. So I was just wondering, in light of what you guys are proposing, are those exceptions to be made on the county level when it comes to how law enforcement would be going through with this, or is that on the state level to decide what those exceptions would be?
Well, we're not for a ban. You can't, I'll let my colleagues speak for themselves, but the idea here is to have a more closely controlled, stronger set of controls on a statewide standard for no-knock warrants. And I don't believe, frankly, that the local jurisdiction is, as the state's lawyer, I don't think that they can overrule a state statute. But that being said, this is not a ban. I don't favor a ban because you cannot adequately foresee every possible instance where a waiver to the knock and announce requirement might be necessary to preserve life. And I think the more important issue is to have a good check and balance by an independent elected judge with a clear standard in statute that limits it. But as each of these prosecutors has testified or has just talked about, this is not a commonly used technique in Ohio. It certainly does get used. It probably gets used a little bit more now than it did years ago. But you can't import the things that you see from other states into Ohio. This is Ohio, and frankly, I think we do things a lot better here than many other states.
And one last thing, can you describe the process that this will have to go through on the state level to make these slight changes that you're referencing?
Sure, and I don't think that they're slight. They are perhaps lawyerly changes, but the law is what governs the waiver of the knock and announce requirement. And these are actually significant changes into the level of proof and what has to be shown in order to justify it. The process is both houses of the General Assembly would have to approve it by a majority vote after committee hearings, and then the governor has a chance to sign it or veto it. And Joe, since the question involved Cincinnati City Council, I do want to circle back to you and ask if you have anything you'd like to add with regards to Hamilton County.
Well, as you know, the city of Cincinnati only makes up 40% of the county. However, they make up the bulk of our search warrants. They requested, Councilman Smitherman requested an opinion, and based on the way our city charter is written, whether or not council can dictate to the police by what method they execute search warrants. And the city manager and the city attorney who come back with an opinion basically saying you can't do that to our police based on our charter, which, you know, as you know, Dave, is unique throughout the state. All city charters are unique in some fashion, but the city manager can order it. I think, Dave, I think your leadership here really will, in terms of a statute, help other jurisdictions on guidelines. In our jurisdiction, I think our requirements are quite heightened to protect people from these, especially if it turns out to be a bad warrant, search warrant. There's a lot of protections involved right now that are being used in the Cincinnati area. But I do very much like the letter you prepared, and hopefully the legislature and governor will act quickly to at least put some statute meaning behind what we're talking about in terms of being cautious and not just in Hamilton County or Franklin or Cuyahoga, but around the state.
The next question is from John Fuddy with the Columbus Dispatch.
Thank you. I have a couple questions. The first one is for Ron O'Brien. Ron, you mentioned that no-knock warrants are used more often in Franklin County than in Cuyahoga County, but do you have any specifics about how often, any numbers about how often they're done in Franklin County?
I do not, John. I thought I heard Mike O'Malley say that they've only found one such instance in the last number of years, and I know that we have had more than one anecdotally. I know Deputy Chief Tim Becker, when he testified before the Columbus City Council, when they considered and did pass a process internally that they wanted their employees to follow when a no-knock search warrant was sought from a judge. And as I'm parenthetically, as a former city attorney, I think that they do have the power under their charter to dictate to police officers who are their employees the circumstances when they will do or not do certain things. I believe that Deputy Chief Becker collected that information in his testimony to city council. So at least I think you can get that information from him. But again, I'd reiterate, I think it's fairly rare here. However, my point was, I think that it's not just one time in the last 5 years, such as I understood Mike to have said.
Okay, and then my second question is for Mr. Yost. Were these changes drafted by your office and then sent to the big city, big county prosecutors to review? Or was this like a collaborative process where you asked for recommendations? I guess I'm kind of curious about the process by which you arrived at these changes, proposed changes.
So the original draft was prepared by my office. We reached out to a number of stakeholders for input, including the three prosecutors that are with me today. They each had input. And we also received some input from the Buckeye State Sheriff's Association. And I believe that that input is largely reflected in the final draft.
I would add to that, David, that I also had others in the Ohio Prosecuting Attorneys Association review it.
I want to make sure I'm clear with what I had said earlier. We average right around one or a little bit less per year. We get a couple asks, but we screen these when we are asked by law enforcement. And on average, we do perhaps one a year.
Okay, the next question is from Dustin at Gongwer.
Hi, General Yost. I was wondering if you've talked to lawmakers about these proposals yet, and is this something you're hoping that can get done in lame duck session, or is this more of a conversation starter for the next General Assembly?
Well, it would be lovely to try to get it done in the lame duck session. I expect that the General Assembly will consider, there's several different law enforcement bills that are floating around involving training, licensing, and other matters. This would be a ripe amendment, it seems to me, to one of those bills. But the Attorney General gets neither a vote nor a veto in the General Assembly. So I'm raising the issue with my colleagues in the hope of gaining the attention of our policymakers.
Okay, the next question is from Danielle at NBC4. This question is for Prosecutor Ron O'Brien.
Hi, so I have a question regarding the ordinance in in Columbus. So in regards to the ordinance in Columbus when it comes to no-knock warrants, and if this passes and the governor signs this, what happens with that ordinance in Columbus in regards to the statewide regulation that we're going to have? Is that going to change anything, or
That's a very good question, and I think the law of statewide concern for municipal home rule cities under the Ohio Constitution, that the municipal ordinance would still, if it's not in conflict with the state statute, would survive. And at least as I read it, it would not be in conflict. What they required was internally that you don't go to see a judge until a deputy chief has authorized the detective to prepare the no-knock search warrant. And so I think procedurally, and the general rule would be that procedurally they can tell their officers how they want them to do their job in some of those issues, but the state law, as long as it wasn't in conflict and it doesn't reach down to that kind of who must internally in the police department approve it, since it doesn't reach down to that, they could be harmonized together, and the city ordinance could still be operative even if this state statute passes. At least that's my view. And I think I have talked to Zach Klein about it, the current city attorney, and I think that's his view as well.
Wonderful. Thank you so much.
And I would concur, Ron, with your analysis. I think that's right.
Next question is from James Pilzer with Channel 12.
Good afternoon. This is there's a specific question for Prosecutor Dieters, but then a question for the whole group. Prosecutor Dieters, as you know, Cincinnati is trying to advise its city council not to put on a full ban of no-knock warrants. Can I get your take on that specifically? And they told me that they had used no-knocks 12 times in the last year, at least in the city. Can you give me the up-to-date numbers on how many no-knocks have been used in Hamilton County in the last year? And then just a question for the group. I had to jump away, so if this question got asked already, I apologize. But backing up to the 25,000 foot level, how much introspection have you done as prosecutors, given all of the discussion around the Black Lives Matter movement, what happened with Breonna Taylor and all of that, and how did that lead you to this point where you're actually looking at this kind of change? Did those instances spark this conversation? Thank you.
Well, David, I assume you want me to answer first. The city of Cincinnati, the way the charter is written, prohibits the city council, and I might add, thank God for this, they cannot tell the police how to run their department. It has to come from the city manager of the city of Cincinnati, and by such through the mayor. They can, and Ron, you were a city solicitor and would be better off answering than I am, but they can make the requirements in terms of their employees tougher than state law to make it more protective in terms of search and seizure. But they can't crank back on it and make it more liberal for them to be able to do that For instance, if the Attorney General Yost is successful at this statute being passed, the city couldn't come in and say, you don't need any reason for a no-knock warrant. Just tell us you want one, you know? So these are all unique to separate city charters around the state if they've adopted a city charter form of government. And in Cincinnati, they cannot do it. So
Yeah, and Councilman Seelbach has been very clear. This is an advisory, non-binding motion to the city manager saying, we want you to do this, but it's up to you. He was very clear about saying that.
He would be correct in that read.
Right.
And I will say this again, CPD and the sheriff's office are very, very rarely asking for this type of a warrant to be served. And if and when they do, it has gone through multiple reviews at the city level for sure before they even go to a judge.
Do you have a ballpark number on how many have been issued in Hamilton County in the last year?
You know what? We had all the numbers, and I can get it to you. But these numbers, according to the city, according to this morning, the actually served, where they actually got the person that they requested through a no-knock warrant. The last 5 years have been less than 5 people total.
Okay. And just like I said, my question for the group, given everything that's happened this summer, how much of that plays into what we're talking about here? General Yost, you want to take that one?
Sure. I think that's an element of the conversation. But we had a situation in the city of Columbus that was just a few months ago. It was not a no-knock warrant. The police did announce and executed a warrant. The homeowner says that they didn't hear it and began opening fire. And BCI aided in the investigation of that officer-involved critical incident. But that highlights the existence of the Castle Doctrine as a policy in Ohio and the tension there. And the debate in the public space, which I suppose is substantially driven by the Breonna Taylor case and perhaps several others, is part of it as well. So I think there's a group of circumstances that are causing us to take a look at a statute that's been on the books for a long time, and that we can strengthen the controls, make everybody safer without taking away an essential tool for the law enforcement toolbox.
Thank you.
Okay, the next question is from Joe Paganakis at Channel 5 in Cleveland.
Attorney General, I appreciate the amendments that you're proposing. This question I'd like you to respond to, and I'd also like Prosecutor O'Malley to respond and get his feelings on this thing I'm going to ask about. Would you consider, Attorney General, adding a component that would call for examining better training with respect to the implementation of officers at the scene of these types of warrants?
Well, certainly. Training in every aspect of law enforcement is always on the table because every cop I know wants more training. Every cop that I've ever met wants to be better next week and next year at what they do. So I think that that's entirely appropriate. We are currently undertaking a top to bottom review of our training out at OPATA, and that's within my office. I frankly don't think that we need a statute to do additional training where it's warranted. What we do need is funding under the current law. We cannot mandate training without providing corollary funding for it. And one of my top priorities this year is to gain a independent, segregated, locked down funding source so that we can have annual training in Ohio for our law enforcement. That happens to our south in Kentucky. They have a funding source and have annualized training for every officer. But in Ohio, it's a bit more hit and miss. And there are many years where there's no state funding available, and it depends upon local resources, if there are any, and frequently there aren't. So I think that your question is well taken. It sweeps more broadly, though, than simply execution of search warrants.
I understand, but again, you'd be willing to look at specific curriculum with regard to how officers implement these warrants at the scene. Is that correct?
Well, don't make the assumption that we don't train on that now in Ohio. There is training for tactical officers. And what I'm willing to certainly do is always look at best practices and incorporate those as we go forward year to year to get better.
Prosecutor O'Malley, would you agree that an examination of training with respect to how officers conduct themselves in implementing these no-knock warrants is crucial?
I think one thing is clear is if you talk to any police officer, they will tell you executing search warrants is some of the most dangerous work that they do on a daily basis. And certainly, I know for certain they are trained as tactically on how to handle search warrants because they are such dangerous circumstances when you enter a home and are unaware of exactly what's behind the door. So certainly working with OPATA, certainly additional training, but also additional equipment. You know, when the officers are executing search warrants, they need to have the best equipment available. And, you know, as you know, in Cuyahoga County, we've got 60 plus municipalities and villages and townships. We have to be able to make sure that all departments have the appropriate equipment and the appropriate training so that when officers are performing this extremely dangerous action, that they are protected. And again, they're trained in an appropriate manner.
Thank you, guys.
Okay, the next question is from Parker Perry at Dayton Daily News.
Good afternoon. I wanted to touch base with General Yost again. We're approaching the 1-year anniversary of the death of Detective Del Rio. I know you had mentioned previously the Columbus incident. It sounds somewhat similar. I don't believe Detective Del Rio's circumstances was a no-knock warrant. However, it kind of played into kind of like one because the defendant, I believe, had said that he did not hear the police enter the home and thought he was being robbed. I'm not sure if that's true or not, but that's what's being said at least. I wanted to see if his circumstances around his death played any role in these conversations as well.
Well, Detective Del Rio's murder was a huge loss to the Dayton community and to Ohio, and I still grieve for his family, who I had never met until his funeral. But it illustrates what Prosecutor O'Malley just said, which is these are dangerous operations. Even when you knock and announce, they're dangerous operations. And I think it's important that we recognize both sides of the equation, that there is danger to the community, but there is also danger to our officers who are, after all, trying to execute the laws of this land to protect the citizens of this state. And that's what this initiative, this proposal seeks to do, is to strike the balance between protecting the community and protecting the officers who protect the community.
Thank you.
Okay, the next question is from Susan at the Ohio Capitol Journal.
Thanks for having me. I just wanted to know if you could explain this a little bit. Is there any discussion of allowing no knocks only by special response teams or by special teams that have specific training, whether that be beyond the OPATA training for no knock warrants?
So that's not currently something that we're proposing to require. I'll let my colleagues speak to their views on whether that would be advisable. I think there's a practicality issue of there may be jurisdictions or moments when that's necessary, and requiring some kind of an elite unit to exist in every police department carries its own challenges.
I'd say here in Columbus that there's a designated group that does do these kinds of search warrants.
Generally speaking, in Cincinnati, it's the same way, but we're dealing with 88 counties, as the Attorney General knows, and resources and things of that nature are quite different from county to county. But this gives a good framework for this proposed legislation, gives a good framework for even smaller counties that don't have a tactical unit available, that they know what they got to do. The judge is going to read the statute and hopefully follow the law and enact it.
The next question is from Bennett Haberly at Channel 10, and this will be the last question.
Thanks for taking my question. This is for the group, either for General Yost or for the respective county prosecutors. Have any of your offices ever conducted an audit of these warrants to see not only to look for no-knock warrants, but to look at other warrants where there may have been anomalies, where warrants that were sought maybe didn't produce what they were seeking, or there were errors that occurred? I'm just curious if there has ever been a deep dive in any of your offices looking at some of these instances.
Well, there's a deep dive on darn near every case. It's called a motion to suppress, and they file these motions quite frequently when a search warrant's issued to quash the evidence that was seized in that particular warrant. So the judiciary, not directly, but almost invariably, are going to be reviewing these warrants for their validity and their applicability in that particular serving of a warrant, to determine whether or not the evidence even comes in. So it doesn't do the police any good to execute a bad warrant that's going to get the stuff quashed in court. But in terms of a formal audit, that's above my pay grade, and that would be the Attorney General.
Now, I would add, Bennett, that we did do a formal audit several years ago of search warrants done by the Reynoldsburg Police Department, because there were two officers that were both stealing drugs and money from drug dealers, which, not surprisingly, don't report that to the police. And so we went through and did an audit on all search warrants that they had done during the prior 5 years or so, whether they were no-knock or whether they were regular search warrants.
I will, to the global issue, having spent 8 years as the auditor of state, knowing a little bit about audits and audit standards, the kind of thing you propose would be a useful piece of information. I'm not sure how you would construct those audit standards. It would be an extraordinarily difficult audit program because of the variability in the cases. These are frequently one-off fact patterns, and the number of moving parts, particularly at the execution end, it becomes very difficult to compare them one to another and draw any meaningful conclusions. And for the record, I appreciate Brother Dieter's comment, but his pay grade is substantially higher than the Attorney General's, and I have to demur there a little bit. So thank you all for joining us, and we'll look forward to continuing the discussion in the marketplace of ideas, hopefully get something through the General Assembly yet this year.
Thanks, David, and anything we can do to help, let us know.
Thank you, Joe.
Thank you.
Mike, Ron, thank you.